first case is Morgan Building Group LLC versus Owner Insurance Company. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your arguments, if that applies. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. Kristen Campbell on behalf of the appellants. Good morning, counsel. The issue that we have in this case is very narrow. We were looking at a dispute regarding testimonial privilege, protecting the attorney-client privilege. The legislature has set forth a very specific manner that we are to use when we are addressing such a dispute. And our contention is that the trial court in this case failed to follow that procedure. RC 23-1702 requires 2 steps. First, the party seeking to invade the privilege must establish a prima facie case of bad faith by the insurer. And second, the court must conduct an in-camera review of the proposed testimony to ascertain whether the communication is related to the attorneys aiding or furthering a commission of bad faith by the insured client. The trial court here referred to the statute when she was ruling on owner's motion for protective order. But if you look at her opinion, the rationale that she used was from Boone versus Van Liner. The problem with that is that the legislature expressly modified Boone in 23-17.02. So the trial court held that attorney-client communications which shed light on bad faith by the insurer are not worthy of protection. If you look at the general notes to this statute that was amended in 2007, well after Boone, the legislature said all attorney-client communication is worthy of protection. We are absolutely mandating that. We are stating that it is a substantial right, and we are saying it is the public policy in Ohio that regardless of the substance of the communications, they are worthy of protection. So it was improper for the court to harken back to Boone in order to substantiate her decision on that issue.
I guess, counsel, I'm trying to figure out, since they're alleging, and since it seems like there is a deposition at Edinburgh or whatever, that indicated that the attorney for owner's insurance was actually the decision maker in all this. So basically, it's almost like the claim is that he's the bad faith actor. So how in the world do you get any information if everything's controlled by attorney-client privilege? Because this is unusual for that allegation to be made.
To address your question, Your Honor, I guess the first step is that's an allegation. That is how the plaintiffs have framed the issue. If you look at the testimony of Melody Pettigrew, she has conflicting testimony on that issue. So first, it's only an allegation, it hasn't been proven. And secondly, it does not establish a prima facie case of bad faith action by the insurer. So
to this extent that this is only an allegation, we're talking about a discovery rule, right? I mean, discoverability is not based on whether or not it's admissible evidence, but it's whether or not it's going to lead to any admissible evidence.
I disagree in the extent that the statute says you have to have at the baseline in order to invade the privilege in this particular instance a prima facie showing of bad faith. So the problem with Boone, if you look back at Boone said if there's an allegation of bad faith, then people can obtain a claims file. So everyone started throwing out allegations of bad faith, saying here, bad faith, no matter how the insurance company handles the claim, we're gonna say bad faith, we're gonna get your claims file. So what the legislature did with the amendment is try to rein that in and say when you were talking about testimonial privilege, you can't just throw out allegations. You have to establish a prima facie case before you can get into that discovery issue. And then if you do get into that discovery issue, there are very specific requirements, including an in-camera review of the purported testimony before anybody is even allowed to dive into that.
So the journal entry says that the judge did make a previous prima facie case finding of bad faith, but where's that in the record?
Our contention, Your Honor, is that it is not in the record. It is absolutely not. There's not a finding in any way, shape, or form that the trial court did make that determination. And in fact, the only substantive ruling on the bad faith issue is that the court found that there was a question of fact and therefore denied auto owner's motion for summary judgment. So in addressing the motion for summary judgment, the court could have said, look, auto owners, you didn't even meet your threshold burden under Rule 56. The other side isn't even required to respond because you didn't show that there's no way that the plaintiff can win on this issue. And she didn't do that. She said there is a question of fact. There is disputed testimony and it could go one way or another.
So is that analogous then to this or not?
No, that's the antithesis of finding a prima facie showing of bad faith.
There's a burden in summary judgment, right?
There is a burden in summary judgment for the moving party to establish, based on the record, here are points in the record that show there is no reasonable conclusion that can be favorable to the other side. If the defendant meets, or whoever the moving party is, meets that burden, then the other party has a corresponding burden to say, there's at least a question of fact, and the court has to look at that in the light most favorable to that moving party. That's not the same thing as establishing a prima facie case. Saying that you survived summary judgment does not say there's a prima facie showing. And there's nothing in any of the discovery rulings that show that there is a prima facie showing of bad faith. The only review that was done by the trial court, frankly, if you look all the way back to the only review that was done by the trial court, it was back in 2021. Auto owners submitted a privilege log and said, here, we're producing our claims file because there is an allegation of bad faith. Because you have requested the claims file, we will give you most of it. But here are the redacted claim notes, and here are the items that we are claiming are privileged as attorney-client communication. So the trial court looked at that and said, based on your privilege log, are these documents properly classified as attorney-client privilege? And she held yes, they were, and therefore they were not discoverable. Then as the case moved on, there were other issues that came up and the court made rulings. But A, there was no other in-camera review. There's nothing showing it on the docket. There's no hearing to address the issue. There's no writing about it. The court just said, here's what's going to happen. So we can't show through the docket that there was any additional review, and any additional review that would have taken place would have been to look at, does the communication shed light on or cast light on whether the insurer committed bad faith one way or another. When you're looking at the testimonial privilege under 23-1702, the question is, did the attorney aid or further any bad faith? So it's a different review process. So even if any of the prior reviews had been sufficient, which we claim they were not, she didn't look at it under the lens that you have to look at the issue when you are talking about testimonial privilege. The court did not make any substantive findings about the bad faith issue in itself. And what plaintiffs have alleged is, well, you found that the attorney participated in the decision-making process. To your earlier point, did the attorney make the final decision? So first, the evidence is not clear on that issue. And secondly, even if the attorney participated in those decisions, there are a couple things to look at. First, participating in a decision is not anything that's unusual. This case was in litigation. This loss happened in 2018. The plaintiffs immediately obtained a lawyer. The insurance company immediately obtained a lawyer, and it became adversarial almost immediately.
Counsel, let me stop you. I know you cut your argument, but I was going back through the statement of the case and facts, and I was a little confused. Walk me through how this, I understand there was the allegation of, saying the property was more than it was, paid for more than it was, all these things. But they did initially pay out some money, $300 and some thousand.
Right.
And then they eventually denied the claim.
Correct.
What was the basis of the denial?
The denial is set forth in a letter that was written in 2019, and there are several issues that were addressed in that letter. One was misrepresentation about the purchase price. Another was misrepresentation about the value of the building and repairs that had been done.
So what I'm wondering is, why would the attorney for owners have to ask for permission to use misrepresentation when that was part of the denial?
Because the denial happened after litigation had been filed. There was
Now I'm
no
getting it straight.
possible way for the insurance company and the insured to have any communications together, because by that time, litigation had been filed. First, there was an adversarial relationship before the litigation was even filed, and secondly, once they filed that federal lawsuit, it was impossible to go around the attorney. The attorney had to be involved.
So how long was it that they waited for either denial or approval of the claim?
The denial letter, I believe, was August of 2019,
Okay, which would have been how long after the fire?
about a year.
Which is, obviously can be evidence of bad faith in itself.
It could be. So if that were the case, the plaintiff was free to file a motion for summary judgment on that issue and try and get a ruling from the trial court if it were that cut and dry. So the plaintiff moved for summary judgment against the welder, saying on a liability issue, you were liable. They were free to file a motion for summary judgment on that issue. They were free to conduct discovery on that issue. They were free to hire an expert witness to address whether that was an appropriate claims practice, and they didn't do it. Had they done any of that, then the trial court could have made a substantive ruling on the bad faith issue, and she didn't. Therefore, the record is completely devoid of a prima facie case of bad faith.
We have about 3 minutes and 30 seconds left. Do you want to reserve any of that time?
I'll reserve all of it for rebuttal, Your Honor. Thank you.
Good morning, Your Honors. My name is Ken Myers. I'm here on behalf of the A. Morgan Building Group. I'm accompanied by my co-counsel, Justin Alberta. I wanted to just take a step back and set the table where this case is at procedurally. This is an interlocutory appeal of a discovery dispute. The court early on in this appeal raised the question of whether it's even a final appealable order. We briefed the issue, and the court hasn't ruled on it, which is why we're here, but I do want to reiterate that the issue of whether they're even entitled to be here is in dispute, because we don't have an order compelling the release of confidential information. We have the denial of a protective order. And the distinction is that I think there's an assumption by the appellants that the taking of the deposition of Mr. Winchester automatically equates to the violation of attorney-client privilege. And that's not necessarily the case. As we've said in our briefing, Mr. Winchester basically took over the claims administration. I think Judge Carty raised that issue.
Did he take it over, or was he giving advice to a client?
I think he crossed the line, and while opposing counsel says, it's just an allegation, there's evidence. Ms. Pettigrew's last deposition, where she talked about what was in the claims notes, indicated that regardless, I understand that lawyers get involved in cases, but Ms. Pettigrew's testimony is very clear, not only that she was recanting her prior testimony that she was the final decision maker, but she basically said it was Mr. Winchester and corporate counsel. And she also said that, once the case went to an attorney, her hands were off it, and it went to the attorney. He was doing all of the functions of the administration of the claim. So I think that, number one, he crossed the line, and because of that, we should be entitled to ask him questions, at least as to his role in the claims administration. Now, we may not ever hit the point where we ask attorney-client privileged questions. I've suggested at the trial court level that for the deposition, that the court assign a magistrate to sit in on the deposition and rule question by question whether there's a privilege. And it may be at that point, if a question is asked that clearly is privileged, and the court orders Mr. Winchester to answer, and his attorney says, don't answer it, that's privileged, that's when we come here.
Counsel, let me ask you about something that the appellant's counsel raised, and that is, because obviously the claims process itself could have been evidence of bad faith. She says, maybe you should have filed a motion for summary judgment, and all this prima facie evidence could have been developed, in regard to what happened.
Well, I think one of the things that's important to remember is, and the appellant's counsel touched on this, is this case rolled out in stages. And the trial court treated it very deliberatively and in order of when things needed to happen. So the initial ruling, when we asked for the claims notes, was no, not at this stage. Then we developed further evidence, and we asked again. The court said, okay, I'll do an in-camera review. The court obviously did an in-camera review because she denied some of the claims notes. And so she said, okay, I'm going to turn them over. And then, based on the claims notes, and it's quite clear in the claims notes and in Ms. Pettigrew's testimony what an outsized role Mr. Winchester had, and the court had already ruled that Mr. Winchester had an outsized role in the claims administration. So based on that, we said, okay, we still don't have an answer on who made the decision to deny the claim.
Well,
Now Ms. Pettigrew says two things.
Isn't this case about whether the judge properly construed the statute? She was supposed to make a prima facie ruling about bad faith, and we don't have that in the record specifically. And then we have some claim notes that have been ruled on, but now we're talking about going from claim notes to proposing an attorney, not an in-camera review. Are there steps skipped here if you're strictly construing the statute?
Well, I think I'll take each of those separately. On the in-camera review, the court did an in-camera review.
Of the notes.
Well, of the notes, and then the court reviewed, in addition to the notes, the testimony of Ms. Pettigrew. So whether the court labeled that as a new in-camera review and whether the statute requires a second in-camera review, the statute's silent as to that. So I think on the in-camera part, I think the court did that but didn't properly announce that she had done that. As far as the prima facie case, what the court did was in the latest ruling on the attorney-client on the deposition, she said, I've already made the ruling that's prima facie.
She said, I already made the ruling, but where is that in the record?
I think the ruling itself is the ruling that was prima facie. I think, as I said in my brief, the court surely could have been clearer about what she was saying and about where she was in the procedural hierarchy. But the ruling itself, she wouldn't have. She studied the statute. She cited the statute, so she wasn't going to allow us to do the deposition without having made a prima facie ruling, where the court made I think an error, but a de minimis error is saying, I've already ruled it prima facie, when in fact that's what this ruling was. So in terms of strict construction, yes, I think it would have been better had the court laid out that step and said, I am ruling now that it's prima facie, instead of using the language, I've already ruled that it's prima facie. But I think that's kind of a distinction without a difference, because the ruling itself was saying, based on the statute, I'm ruling that they made a prima facie case. And the ruling was based on the additional information the court had, which was Ms. Pettigrew's subsequent deposition based on the claims notes. So I think if you stack them all together and put them in sequence and look at how long it took the judge to allow us to get to that stage, I think the judge has met all those requirements. So yeah, language could have been a little clearer, but I think she met the requirements. The other thing I'd like to touch on briefly is this case stands and falls, I believe, on the interpretation of the statute. The only other legal citation that the appellants have listed is this Squire Sanders versus Give Out and Flavors Corp case, which this court already ruled in its first ruling on this case, really is not relevant to this issue because it's not an attorney, or it's not an insurance bad faith case. It's basically an attorney's fees case regarding attorney-client privilege. So the only thing I think this court's left with to rule on, if it's going to just look at from an appellate standpoint, is the statute. And I think, Judge Lansbury, you hit the nail on the head when you talked about, you know, the two issues, the prima facie case and the in-camera review. And I think, like I said, that the court has met those standards. And, you know, if you go back again to the issue of whether this is a final appealable order, because this case has been so incremental, I don't think the threshold issue is whether we get the deposition. I think the deposition should go forward, and within that context, if alleged attorney-client privilege issues come up, then the court can rule on those as they come up, and then they can come back if they feel that it's being impinged on. But I think it's clear that we're entitled to ask some questions about Mr. Winchester's involvement in the claims administration that may not even touch on attorney-client privilege. So it's not just the fact that we're deposing an attorney.
You're saying an attorney who took on a different role than being the attorney.
Right. Let us have the deposition where we explore what his role was, what decisions he made, and then if we get into things where the question is who did you talk to or who within the organization did you communicate to that are not mentioned in the claims notes, that are not already out there, there may come up some narrow issues of clearly privileged information. But remember, the statute basically carves out an exception that says attorney-client privilege is sacrosanct, except in the case of insurance bad faith claims. And all the court has to do is do a couple of procedural safeguards, which again, the court's done. But otherwise, there is no attorney-client privilege for insurance bad faith claims. So I think there's a whole range of topics that we should be entitled to ask Mr. Winchester about that don't even arguably touch on attorney-client privilege. Because, not just our allegation, but because of the role that Ms. Pettigrew testified under oath that he played. And I think we're entitled to have that information. And again, at the risk of, offering to come back here again, I think procedurally that's what should take place. Let us have the deposition. Let them object to specific questions if we even get there, even if we get to attorney-client privilege issues. And then let them take their interlocutory appeal if they're worried that the horse is about to be out of the barn on attorney-client privilege. So if the court has no further questions, I would ask that the court affirm the trial court and allow us to go forward. Thank you.
Counsel, what about that? He's saying basically you're premature, that this isn't a final appealable order because there's a motion for protecting, denying that instead of actually an order to compel.
I disagree, Your Honor, for a couple of reasons. First, the substance of the motion for protective order was we asked that the deposition not go forward at all. There weren't limitation saying we ask that the deposition be limited so that attorney-client privilege matters aren't encroached upon. We said we want to block the deposition, and the court said no. And in fact, if you look at what the court said in the entry, she said Attorney Winchester played a large part in denying ANVG's claim. As a result, and pursuant to RC 2317-02A2, the attorney-client privilege does not apply. So I think the court already jumped ahead and said, you don't even get to assert the privilege. This deposition is going forward, and as it goes forward, you don't even have the right to assert a attorney-client privilege because I've already told you it doesn't apply.
What if they had the deposition and a single question allowed to be asked, and then depending on the answer, obviously it could go further. But the first question is, did you make the decision to deny the claim?
I'd say that is improper because
How's
here's
that
the thing.
attorney-client privilege?
Because we haven't met the terms of the statute yet.
Well, I'm just saying
And-
hypothetically, if we have a deposition going forward, what would be wrong with them just asking the attorney, did you make the decision? Now, if he says, no, I didn't make the decision, then they have to go home, I think. If he said, yes, I did, then that opens up the attorney-client.
Because making the decision in and of itself isn't bad faith. There's not a single statute or case in Ohio that says that if an attorney providing advice to an insurance client makes the final decision based on law, based on experience, based on deposition testimony, that that's bad
But do
faith.
you have to even go into the statute then? Because the fact is the attorney's not acting as an attorney anymore. He's
Yes.
acting as an office holder and a decision maker.
Yes, there's nothing in the statute that carves out an exception for if an attorney makes a decision.
We have to be in
litigation.
I think, maybe I'm wrong, but I would think you have to be acting in the capacity as an attorney before you have any privilege.
Yes, but that could be corporate counsel, that could be personal counsel for a witness, that could be any number of things. Here, it's litigation counsel. And he was counseling an insurance company who had been sued for bad faith. And under the statute, you don't get to hold a fishing expedition to decide if there is bad faith. You only get to even look at these issues if the moving party has made a prima facie case of bad faith. You can't do a deposition of a litigator in order to get the information that you need to support that allegation in the first place. There has to be something else in the record for you to even get there. And in this case, since the court jumped ahead and said we're not even going to allow you to assert that privilege, and because that ruling was based on Boone, it's improper.
And you're out of time, so if you could wrap up in about 10 seconds. We appreciate
Okay.
that.
Thank you, Your Honor. We would ask that the case be remanded. The discovery was done, motions for summary judgment were completed, the case was ready for trial. We think that the matter should be remanded and that the deposition be precluded and the parties just go to trial without having that information. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations today.
Thank you.